I'm curious as to, was there slurred speech? Were there bloodshot eyes? I'd like to know about the indicia of intoxication.
That's about where I was going next, Judge.
So, Mr. Flood, you ready?
After Judge says get on it. Dog on it. Okay, pause for a second. Did you catch that? The judge is basically saying, cut the fluff and get straight to the point. Courtroom translation, no patience for stalling.
I'm sorry, I did the state pass.
State pass witness.
All right. Yes, I'm ready, Judge.
Okay.
So where to begin? You saw the video that we all watched of you approaching Mr. Martinez, right?
Yes, sir.
And despite your insistence on what you're telling, well, you told the jury that you asked him how much he had to drink, or if he had been drinking, right? That he admitted he had.
Yes, sir.
It's not illegal to drink alcohol and then drive if you're not intoxicated, right?
Correct.
Are you a drinker?
No, sir.
You don't drink any alcohol?
No, sir.
Okay. Do you think everybody that drinks alcohol and then drives is guilty of DWI?
No, sir.
So you said you were out that night as a speed to look for speeders.
It was traffic enforcement. Yes, sir.
I think you said you were out there looking for speeders, and also
You're a hammer, everything looks like a nail. That's a heavy line. The defense is planting a seed of doubt. Was this officer just looking for a DWI no matter what? This is a classic move. Make the jury question whether the cop saw what was real or what he wanted to see.
drunk drivers.
Yes, sir.
So you were like the speeding and drunk driving enforcer that night.
Correct.
Are you familiar with the saying that when you're a hammer, everything looks like a nail?
Sure.
So that was kind of your role that night. You were out there looking for, it was the night shift.
Yes,
You're
sir.
looking for people to arrest or pull over for DWI, right?
Correct.
And you happen to find someone who looked like a nail. He was speeding, and you smelled an odor of alcohol, right?
Yes, sir.
Now, you wrote an office report in this case, correct?
Yes, sir.
And you wrote that close in time to when this happened, right?
Correct.
You bring a copy of that with you?
Yes, sir.
Okay. I saw you kind of looking down earlier. It's okay to refresh your memory because I know it was a little time ago, but can I just ask you, you don't read directly from it word for word, but I mean, if you say, hey, do you mind if I refresh my memory? That's fine. Okay.
Okay.
You stated that you smelled an odor of alcohol on his breath.
Yes, sir.
And that was when the state was asking.
Having the odor of alcohol doesn't prove intoxicated. Exactly. Smelling alcohol is like smelling pizza. It doesn't tell you how many slices someone ate. This is a defense hammering home that suspicion isn't the same as proof.
Questions right here.
Mm-hmm.
You didn't say I smelled a strong odor of alcohol.
All right.
You didn't say I smelled a heavy odor of alcohol. You just said I smelled an odor of alcohol.
Okay.
Right?
Yes, sir.
You could have said, when they said, what did you smell? You could have said, I smelled a strong or heavy odor of alcohol on his breath, right?
That's correct.
But you did not say that.
That's correct.
But you'd agree with me anyway, though, that just having the odor of alcohol on your breath, that doesn't prove a person's intoxicated.
That's correct.
Everybody knows that, right?
Yes, sir.
It doesn't even tell you how much alcohol a person has consumed, right?
That's correct.
Even if you said a strong odor of alcohol, that doesn't mean that, well, that person's really consumed a ton of alcohol, right?
Correct.
Okay. So he admitted to drinking. You smelled the odor of alcohol. That makes sense, right?
Yes, sir.
Okay. Him drinking and him admitting to it and you smelling it, that doesn't mean he was intoxicated, though, right?
That's correct.
Okay. Now, I don't know who's. I mean, I'm 53. My hearing's not what it used to be, but he didn't say I had several. We didn't hear that. Are you telling the jury that that's what you heard? How old are you?
I'm 50.
Do you wear hearing aids?
No, sir.
Do you have trouble hearing? Has any of your family?
In a courtroom, yes.
Okay. Family members ever said something like that? Like they have to me? You have to repeat it? themselves?
That's how it sounds.
After listening to it, I think once or twice, are you still trying to, I mean, you know, you're under oath here, right?
Yes, sir.
And you're still telling these folks here that we all heard that he said, I had several drinks? Or do you want to change that answer now? Just tell us the truth. He never said several drinks.
All right. Yes, sir.
Well, they got this man charged with a criminal offense. You understand that?
Mhm.
If you were charged or a family member, would you want an officer up there not telling the truth to a jury?
Well, in
Objection, Your
no,
Honor.
sir.
No, sir. Is that your answer?
No, sir.
So why is it okay for you to do that? You said it wasn't the truth.
No, I never said that, sir.
Did he say several drinks?
He said a few. Yes.
Did he say, I had several drinks, like you testified to under oath 2 times?
Yeah.
That's an answer, Judge.
Overruled.
Which is it? Because you just said,
Is it that important that you've got to exaggerate? Whoa. The defense attorney is going straight for the jugular here. This isn't just cross-exam. It's character assassination. They're telling the jury, if the officer lied once, how can you trust anything else he says?
no, he didn't say that.
No, he said a few.
Is that fair to exaggerate facts or to tell the jury things that are not true?
No, because a few means several.
If he never said several, he never said a few. You know, you play it again? I'll play it as many times as you want. Can you, if I played it again, can you point out to the jury where he said I had a few drinks? Officer, look, I'm not trying to trick you.
Mm-hmm.
This is important. We want to be fair, right?
Yes, sir.
We want to be fair, right?
Mm-hmm.
Your job's too important to not tell the truth under oath, isn't it?
That's correct.
I mean, is it that important that you've got to exaggerate and make up things that aren't true just to try to convict this guy?
No, I'm not trying to convict nobody.
Well, then why aren't you telling the truth to the jury? We all heard it.
The video showed the truth.
Right. The video shows the truth.
Yes, sir.
You asked him if he had been drinking.
Yes, sir.
He said a little bit. Right?
We can go back and see the video.
Really? It's not important to you? Did you watch the video before testifying?
Yes, I did.
I just wanted to be clear about what happened. And we have the video, and then we have what you're saying the video said. Those don't match up, do they? Yes or no? Is what you told the jury match up with what is on the video?
Yes.
How is that okay? That's not okay. You went up to him and you asked him, have you been drinking? And he said a little bit. Right? I will play the video again. It's in evidence. Do I need to, or will you just agree with me that I...
Say a few. Correct. And there it is, the smoking gun moment. The video doesn't lie. When testimony clashes with hard evidence, the credibility gap widens, and the jury notices.
that that's the truth? Because if you're not going to agree with me that that's the truth, you want me to play it again?
Sure.
You guys mind? Help us drive.
Your Honor, for the record, that's State's Exhibit 2 at the 2-minute 34-second mark.
You stop it. You said, how much did he have to drink? Have you had anything to drink? What did he say?
A little bit.
A little bit. He didn't say a few. Correct? He did not say several. Correct? Okay. So that's not a part of this case.
Correct.
Okay. Go ahead. Thank you.
Then you order for the record, it's 6 minutes or 2 seconds. 6 minutes.
How much drink alcohol for?
You came back to the vehicle. You asked him again, how much have you had to drink tonight? And he said, 1. And you said, are you sure? He said, yeah. He didn't say a few, right? He never said several, correct? Is there anywhere else on the video that he said a few or several?
No, there's a part of the video where it says honestly, yeah.
I'm sorry?
There's a part of the video where he says honestly,
He said,
yes. Honestly, yes.
yeah.
Or yeah.
Well, that's why I wanted to show you what the state showed you. And the answers that you gave don't match up with what Mr. Martinez said, right?
Correct.
We heard you ask him 2 times about drinking. Did he ever say he had a few or several?
No, sir.
But why would you come to court under oath and tell the jury that? Why? That's may I approach the witness, Your Honor? I've got copies of your offense report.
Yes, sir.
I'd like to show them to you. I don't know what you have, but you wrote in your offense report, right, that you asked the driver if he had any alcoholic beverages, right? We heard that. That's the whole purpose of that on bodycam, right? We see the truth. That's the truth.
Right.
Not what you're saying. Right? Right?
Yes, sir. Right.
And he stated, what did you write? He had only 1, and you put O-N-E, and then you put parentheses and the number 1 in there to make sure that there was no confusion in your office report that he said he had 1 drink.
Yes.
You never wrote anywhere that he had a few or several, or that he came back later and said, well, honestly, I have more to drink. Is that anywhere in there?
No, sir.
Is this the kind of police work that you are used to getting away with doing?
No,
So you don't get away with this all the time?
no.
Or you do get away with it all the time?
No.
Yes or no? Do you get away with it?
Objection relevant.
It's not.
On the back, you write again that you asked the driver if he had any alcoholic beverages. That's like 2 places. And he stated that he had only 1.
Yes, sir.
And you wrote the number 1, O-N-E,
Yes.
and then you put parentheses, the number 1. Period. Anything about that I misrepresented?
No, sir.
You approached the vehicle and he was holding his license and insurance out the window.
Yes, sir. Correct.
You were going to ask him for that, right?
Yes, sir.
How in the world is that a sign of intoxication? You said he was bouncing it?
Yes, sir.
That's a sign of intoxication.
But usually drivers.
Is that a sign of intoxication?
No,
Yes
sir.
or no?
No,
Then why are you here trying to tell the jury that it is?
I never said that.
Do you remember 10 minutes ago when they were asking you questions and you said he was bouncing his license and you're trying to insinuate that that was weird or some,
That was an observation.
right, about like his mental or physical faculties?
Yes, sir.
So okay. You talked about NHTSA, right?
Yes,
The
sir.
defendant refuses sobriety tests. Here's something most people don't realize. You have the right to refuse those field sobriety tests. But, and it's a big but, refusing can make you look guilty, even though it's perfectly legal. Smart decision or a risky gamble. That's for the jury to wrestle with.
I know this isn't the manual you received, but National Highway Traffic Safety Administration, that's NHTSA, right?
Yes, sir.
That's an acronym that stands for the federal agency that is the authoritative body on how to administer field sobriety tests, right?
Correct.
And they give you an arsenal of 3 tools, 3 tests. There's an eye test, the horizontal gaze nystagmus, right?
Yes.
You know the name of the other two?
Yes. One return, one extent.
Okay. 3 tests that you can use to administer, and as you said, to determine if a person is intoxicated or not, right?
Yes, sir.
And that's what you were intending to do. You smelled alcohol. You asked him if he would do those sobriety tests,
Yes, sir.
and he said no. People have the right to refuse those tests, right?
Correct.
And he invoked that right. He thought about it. He made a conscious decision and said no, right?
Yes, sir.
Which he has the right to do.
Yes, sir.
Now, what you decide to do if somebody refuses, that's up to you. Right.
Yes. The national
Correct.
highway traffic.
It's up to you. Objection that's non-responsive, Your Honor. I asked a yes or no question.
Both of you guys are, it's just, don't get hostile. Ask the question, let him answer. That's it.
Objection non-responsive.
What's your question?
I said if he refuses or submits, if he refuses, what you decide to do next is up to you.
Yes, sir.
Okay. So